Good morning, afternoon, or evening, wherever you are, and welcome to all the participants who have joined. Participants are to be reminded again to activate the camera as the event will start soon. Okay, seeing that there's been substantial amount, good afternoon, everyone, wherever you are joining us from, and welcome to Indonesia's inaugural UNCITRAL Asia Pacific Days 2023 event, co-organized with Universitas Padjadjaran's Transnational Business Law Department, themed the recent development of UNCITRAL instrument in arbitration and mediation. This event is mainly about the work of UNCITRAL, focusing on dispute settlement, information on the Regional Center for Asia and the Pacific, referred to as the RCAP, its internship program, and the UNCITRAL e-learning modules. We are looking forward to many insights from our guest speakers and of course, from our honorable participants. But before we continue, allow me to introduce myself first. Hello everyone, my name is Muhammad Labibojdi. I am the Master of Ceremony in this webinar, and I will accompany you, the participants, throughout the rundown of this event. Before we start, however, there will be opening remarks from the Dean of the Faculty of Law, or rather the Vice Dean, the UNCITRAL Vienna, UNCITRAL RCAP, and the Embassy of the Republic of Indonesia to Austria. Firstly, I would like to invite from the Dean, Dr. Gusma Siswandi as the Vice Dean for Academic and Student Activities for the first opening remark. Good afternoon, Pak.
Good afternoon, Labib. How are you?
Okay, I'm good. Seeing that you are here, I'll give the screen to you.
All right, thank you, Labib, and also everyone here. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Greetings to everyone. Thank you very much for the opportunity. I would like to greet His Excellency Dr. Demos Agusman, the Ambassador of the Republic of Indonesia to Austria, Slovenia, and also United Nations and other international organizations in Vienna. So good to see you again, Pak Dubes, a long time no see. And also to Dr. Prita, Head of the Transnational Business Law Department, all the speakers from UNCITRAL, Stefan, Athita, and also all colleagues from UNCITRAL, the moderator, Dr. Halita, and all my colleagues and from the Faculty of Law, as well as students and participants. On behalf of the Dean, allow me to represent the Faculty of Law to give some opening remarks. Of course, we are very thankful for this opportunity to have another series of discussion with respect to international trade law and related subjects, especially on arbitration and mediation. So I guess this is the webinar that has been also held before that discusses the topics related to international trade law. And we are very grateful to have this very good cooperation, especially with UNCITRAL and also the Embassy of the Republic of Indonesia in Austria. And of course, such events like this will provide insights and more perspectives for our students, because they could also connect and relate with the practitioners as well as policymakers. Nowadays, we always encourage our students to have more perspectives, not only when they attend the classroom, but now with the development of technologies and everything, we can relate easily, we can connect easily with all our strategic partners, and they are of course very helpful in providing more knowledge to our students. So on behalf of the faculty, again, I would like to warmly welcome all of the speakers, participants, especially to our speakers, and to His Excellency, Mr. Ambassador, Dr. Demos Agusman. Thank you very much for your assistance and our very good collaborations so far, especially with the Embassy of the Republic of Indonesia in Austria. And thank you also goes to all the UNCITRAL representatives and also speakers who have allocated their times to share their knowledge with us. Finally, I hope that you all have a fruitful discussion and successful webinar. Thank you very much. Good morning, good afternoon to everyone. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Pak Gusman, for the brief remark. Next, joining us from Vienna, Austria, is the Ambassador of the Republic of Indonesia to Austria and Slovenia, as well as the permanent representative to the UN and other international organization in Vienna, His Excellency, Dr. Damus Dumuli Agusman, SIMA. Good morning from Indonesia, Pak Dubes.
Thank you, Pak Labib. Of course, it is a great pleasure for me to join you here. I noticed that almost 200 participants joining the webinar today. And this is, of course, a very interesting topic. The topic is about the recent development of UNCITRAL instrument in arbitrations and mediation. I would like to acknowledge first that this is not the first time that the University of Padjadjaran and UNCITRAL conduct the webinar. I remember that in 2021, during pandemic, the similar seminar has also been successfully conducted. And then the second, my impressions that really we are in a very transnational and global world, that how from Vienna being connected to South Korea, Seoul, and then being connected to Jakarta, Indonesia. And this is, of course, to show that our webinar is something about a global thing, about transnational thing beyond the border. So on behalf of the permanent mission of Indonesia in Vienna, allow me, of course, to extend my appreciation and thanks to Mr. Stephen Wolfart, the head of UNCITRAL Technical Assistant in Vienna, and my friends, Dr. Gusman, representing the Dean of the Faculty of Law of Padjadjaran University in Bandung, for organizing this very important seminar. Of course, special thanks also goes to the distinguished speaker, Ms. Athita Komindr, head of UNCITRAL Regional Center for Asia and Pacific in Seoul, and Ms. Hangyeol Kim, legal expert of the UNCITRAL RCAP, and also Ms. Tracy Choi, legal expert of the UNCITRAL RCAP. I was informed that this webinar is actually arranged as the first part of UNCITRAL Asia Pacific program in 2023. So the permanent mission in Vienna is so proud that we can contribute to the program of UNCITRAL in Asia Pacific. Mr. Stephen Wolfart, I would like to say that international trade law and the work of UNCITRAL, either in Vienna or also in New York, is now become a very interesting in Indonesia, particularly amongst Faculty of Law in Indonesia. And in this particular case, I'm proud to announce that Faculty of Law, University of Padjadjaran, where I graduated from, and especially the Department of Transnational Business Law, chaired by Ibu Prita, is one of the best academic community in Indonesia that focusing on international trade law. So they are very, very well in touch with what UNCITRAL is now doing through the working group, of course, which is very active. And I'm glad to see that the engagement of this department is very, very excellent. So currently, UNCITRAL and UNPAD are also discussing another possible program with reference to the program Asia Pacific. So I noticed that now you are discussing about the program on the second semester of 2023, to which I would very much welcome and more than happy to facilitate. So the permanent mission opened the door for this program, and I like also to be engaged with the plan and with the everything that you have already planned to do in the second semester. So I do hope that the existing collaborations between UNCITRAL and UNPAD could be further developed in the future. So dear participants, we are benefited to have 3 legal experts from UNCITRAL secretariats who will update the recent development of UNCITRAL instrument in arbitrations and mediations. I hope we could maximize their institutional memory and of course their expertise for our benefit. Indeed, I believe this webinar is not only beneficial for academic purposes, but also for us as a policymaker. So I wish you a very successful webinar. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Padugus, for the remark. It's amazing to be here joining us for today. Thirdly, also joining us from Vienna, Austria, I would like to invite Stefan Wolfhard as the Senior Legal Officer at UNCITRAL Vienna. Good morning, Mr. Wolfhard.
Thank you very much. Thank you. Well, after all that was said, it is even more of an honor for me to deliver some opening remarks from here in Vienna, of course, from the UNCITRAL Secretariat. And I must say that these remarks, I deliver them personally, but they also come and from her heart, from the UNCITRAL Secretary, Mrs. Anna Jobin-Bray, who could not be present, but sends her warmest regards and her congratulations. So first, of course, I should also address very, very special thanks to Ambassador Damos Dumoli Agusman. Thank you very much, Ambassador. Your warm words have been heard. Dr. Ahmad Guzman Simandi, Vice Dean for Academic and Student Affairs, representing Dr. Idris, the Dean of Faculty of Law at University Padjadjaran, and also Dr. Prita Amalia, Head of Transnational Business Law Department at the Faculty of Law of the University Padjadjaran. Ambassador, I must say special thanks to you again for the ongoing support. There's a history to this, to both University Padjadjaran and to the UNCITRAL Secretariat. The door you have opened in your opening remarks is well noted by us in Vienna and also very certainly by my colleagues in Incheon. I would also like to thank, if I may, the Indonesian government and the University Padjadjaran itself, UNPAD, in Bandung, Indonesia, for the kind support to this event and in general to the UNCITRAL Days and to the UNCITRAL Secretariat. In addition to the persons I've named, there are all those who in the background have also helped make this event a reality, and I would also like to thank them. Now, I have to say that this is an important event for us. I don't think we can overstate this. The UNCITRAL Days are a very important flagship event for UNCITRAL, the United Nations Commission on International Trade Law, and us in the Secretariat, both in RCAP, in the Asia-Pacific region, and here in Vienna. It is an event that, and it should be stressed, actually commenced in the Asia-Pacific region, and that has now been extended to other regions. And the initial establishment of the UNCITRAL Days was to commemorate the creation of UNCITRAL by the General Assembly in 1966. 10 years have gone on since 2014 and the first event in the Asia-Pacific region. The UNCITRAL Days, as you know, Ambassador, and all who are present, are a series of mostly academic events that are hosted with universities and institutions of higher learning in regions, various regions of the world right now, but which started in the Asia-Pacific region. There are a series of academic events to promote awareness of international trade standards and norms, particularly those endorsed by UNCITRAL, amongst law students, the next generation of legal thinkers and policymakers. This is how we like to refer to them in our reports in particular. The UNCITRAL Days are events of an academic nature. They are free of admission charges. In addition to raising awareness of our work and mandate in UNCITRAL, it is our hope that they also provide unique opportunities of capacity building, both for public and private stakeholders, and that they assist participating jurisdictions in their consideration of adopting UNCITRAL texts. The event that gathers us today is also important because it is Indonesia's inaugural UNCITRAL Days and one of the first events of the new session of the UNCITRAL Days in the Asia-Pacific region. And I mentioned that the event was launched in the Asia-Pacific region by RCAP, and it is now the 10th edition, so the 10th anniversary of the series UNCITRAL Days in the Asia-Pacific. The first, this event here is the second of the Africa Days series in the Asia-Pacific region, and it follows very closely the first event that took place last week in with the National Law University in New Delhi. And the next one will take place on 22nd of May in Pohang, South Korea, with Handong Global University. UNCITRAL looks very much forward to University Padjadjaran, UNPAD, and also Indonesia, hosting country, joining the UNCITRAL AP Days flagship series every year going forward. We really look forward to that cooperation and to that synergy. I would also like, if I may, closing these few words, to say thank you to the Indonesian government for its support over the years, in particular with the contributions that it has made and pledged to the trust fund. That is very important for us to continue holding these activities and also supporting travel of representatives of developing countries. And here is where I will stop my words. But once again, I must say there's a lot of warmth coming from the gathering here, and we look forward to a future participation in similar and other events. Thank you very much from Vienna.
You're welcome. Glad to be of good welcome, Mr. Wolfhard. Next, we would like to invite Athita Komindr from UNCITRAL RCAP. Good afternoon, Ms. Komindr.
Good afternoon, and thank you very much. Ambassador Dr. Damos Dumoli Guzman, Excellency, Vice Dean for Academic and Student Affairs, Dr. Guzman Siswandi of Universitas Padjadjaran, Dr. Prita Amalia, Head of Transnational Business Law Department, and our key help in making this event a smashing success. Dear MC moderator, and most importantly, dear students of UNPAD and other universities attending today. Greetings from the UNCITRAL Regional Center for Asia and the Pacific in Incheon, Republic of Korea. It is an honor for UNCITRAL RCAP to co-host Indonesia's inaugural UNCITRAL Asia Pacific Days event. Although it is not our first collaboration, with continued thanks to UNPAD and the Indonesian government. I reiterate Stefan's hope to co-organize an AP Days with Indonesia on an annual basis going forward, and to see future collaborations with Indonesia on a wide range of UNCITRAL issues. Although today's event focuses on dispute resolution, UNCITRAL also works on the progressive harmonization and modernization of international trade and commercial law on many other topics, such as digital trade and electronic commerce, insolvency, public procurement, public-private partnerships, secure transactions and access to credit, and support for micro, small, and medium-sized enterprises, along with many other topics. So thank you again for UNPAD and Indonesia's strong support. I now pass the floor back to the moderator.
Thank you. Thank you, Ms. Komindr. Okay, lastly, before we start, we will have a photo session. I will hand this over to the operators, and everyone else besides the operator can feel free to open up their camera and put on their best smile.
Yeah, I'll wait for like 5 seconds so that the participant can turn on their camera and get themselves prepared. Okay, let's start the photo session. I'm gonna comment 1, 2, 3. And for the second slide, 1, 2, 3. For the next slide, 1, 2, 3. The next slide, 1, 2, 3. And this will be the last slide, 1, 2, and 3. Hand over the screen to you, Labib.
Okay, thank you very much, Nick. Now we are going to enter the main event. We will hear from the speakers. We have very exciting speakers here today. First, there will be Hangyeol Kim as the legal expert of the UNCITRAL RCAP. She will talk about the introduction of UNCITRAL. Next, there will be Athita Komindr. Previously also did the opening remark as the head of the UNCITRAL RCAP. She will be talking about the overview of the UNCITRAL arbitration framework, be it the model law, the arbitration rules, etc. Next, we also have Tracy Choi as the legal expert of UNCITRAL RCAP. She's going to talk about the overview of UNCITRAL mediation framework. And lastly, I think the most exciting part, especially to the students here, there will also be a sharing session regarding UNCITRAL e-modules and the internship program, also brought by Tracy Choi and the current interns, Senya and Husho. These discussions will be guided by Dr. Helita Novianti, SIMH, as the moderator. But first, let me read the CV for Dr. Helita. Dr. Helita is a lecturer and researcher at the Faculty of Law, Universitas Padjadjaran. She is well-versed in international trade laws and has written publications regarding ASEAN and investment laws. She has also completed courses on intellectual property through WIPO and ICEP. Dr. Helita, good afternoon.
Good afternoon, Labib. Thank you, Labib, for the introduction. Good morning from Vienna and good afternoon from Indonesia for everyone. Welcome to webinar, Recent Development of UNCITRAL Instrument in Arbitration, held by Transnational Business Law Department, Faculty of Law, Universitas Padjadjaran. I am Helita Novianti Muhtar. I am moderator in this webinar. I will say thank you for our Vice Dean, Mr. Guzman, PhD, for coming and for welcoming remarks. To start this event, we also thank you for Head of Transnational Business Law Department, Faculty of Law, Universitas Padjadjaran, Dr. Prita Amalia. Thank you also to Mr. Stephen from UNCITRAL, and also Dr. Yur Damos Dumuli Agusman. Thank you for all support. We would also to welcome to our prominent speaker, Ms. Athita Komindr. Hello, Ms. Athita. Thank you for joining with us. And Ms. Hangyeol Kim. Hello, Ms. Hangyeol Kim. And Ms. Tracy Choi. Hello, Ms. Tracy. It's a great opportunity for us to directly get to webinars. Recent development of UNCITRAL instrument in arbitration. We would like also welcome for all participants. We looking here, there are some lecturer and student from Faculty of Law, UNPAD, and other university. We will start this webinar with the parallel session by Ms. Hangyeol Kim, and the second session by Ms. Athita Komindr, and the last but not least, the third session from Ms. Tracy Choi. After the parallel session, we will continue to the Q&A session. For all the participants can give the question from raise hand and chat box feature. And before we start the session, please allow me to read curriculum vitae our speakers. First speaker is Hangyeol Kim, is a legal expert of the UNCITRAL Regional Center for Asia and the Pacific. Ms. Kim has extensive experience in international law, including but not limited to trade issues, criminal litigation, and dispute resolution. She has admitted to DC Bar in 2019. She holds dual bachelor degree from Handong Global University and a GD degree from Hangdong International Law School, and a master degree Master of Law degree from Regent University School of Law. Hello, Mrs. Kim.
Thank you
for
very
joining
much.
us. Yeah,
Thank you very much.
second, yeah, thank you. Second speaker is Athita Komindr. Athita is head of the UNCITRAL Regional Center for Asia and the Pacific, UNCITRAL RCAP. Athita has 2 decades of experience in the field of international trade and economic law, arbitration, multinational dispute resolution, and the rule of law and development. Athita has experience in both common and civil law tradition in the public and private sector and holds the degree from Harvard College, Georgetown University Law Center, and Harvard Law School. Mrs. Athita, thank you for joining with us. And third speaker is Tracy Choi. Ms. Tracy Choi is legal expert of the UNCITRAL Regional Center for Asia and the Pacific, UNCITRAL RCAP. Before joining from the Department of Justice of the Hong Kong Special Administrative Region, she practiced in one of the largest local law firms in Hong Kong. Mrs. Choi received her law degree from the University of Hong Kong and admitted as a solicitor in Hong Kong. Hello, Mrs. Tracy. Thank you for joining with us. Maybe without further ado, we would to Ms. Kim to deliver the presentation. Ms. Kim, the screen is yours.
Thank you very much, Dr. Helis Danubianti, for the kind introduction. So let me share my screen. Greetings from UNCITRAL Regional Center for Asia and the Pacific. I'm Hangyeol Kim, UNCITRAL RCAP's legal expert, seconded from South Korea's Minister of Justice. It is a great pleasure to speak to you today at this event, jointly hosted by UNCITRAL RCAP and Universitas Padjadjaran. I would like to extend my gratitude to the university for their wonderful organization of this event. This afternoon, I will present our organization's mandate and work. Following that, as announced earlier, our head Athita will provide an overview of the UNCITRAL arbitration framework, while my colleague Tracy will delve into the UNCITRAL mediation framework. When world trade began to expand dramatically in the 1960s, states began to realize the need for a global set of standards and rules to harmonize and modernize the assortment of national and regional regulations, which until then largely governed international trade. They turned to the United Nations, thus leading to the General Assembly establishing UNCITRAL in 1966. UNCITRAL has since then become the core legal body of the United Nations system in the field of international trade. The mandate of UNCITRAL thus includes the promotion of the progressive harmonization and unification of the law of international trade, and was designed to address concerns that conflicts and divergences arising from the laws of different states in matters relating to international trade constitute an obstacle to the development of world trade. The key takeaway regarding UNCITRAL is harmonization. The UNCITRAL legal instruments, whether they be treaties, model laws, or legislative guides, promote the progressive harmonization of international trade law and cover the life cycle of businesses ranging from business registration to insolvency. The legal certainty afforded by harmonization is universally enjoyed and decreases the level of risk and transactional costs associated with doing business. UNCITRAL's work is organized and conducted at 3 levels. The first is UNCITRAL itself, often referred to as the Commission, which works through an annual plenary session and sets UNCITRAL's work program. The Commission comprises 70 member states elected by the United Nations General Assembly and representative of the various geographic regions and the principal economic and legal systems of the world. The Commission reports directly to the United Nations General Assembly and its annual meetings, considers the progress of work on its program, reviews and determines the work of the working groups, and also directs the Secretariat. The work of the Commission typically includes consideration of draft texts referred to it by the working groups for finalization and adoption. The Secretariat prepares a report of the proceedings at annual sessions, which is formally adopted by UNCITRAL for submission to the General Assembly. For example, the UNCITRAL Asia Pacific Day Series is included in RCAP's annual report to the Commission, and a detailed informal report is published online in English as an informal Commission document. The second level of UNCITRAL's work organization are the working groups, which largely undertake the substantive work on topics on UNCITRAL's work program. Working groups generally hold 1 or 2 sessions per year and report to the Commission. Current topics are as shown. The third level of UNCITRAL's work organization is the Secretariat, which assists the Commission and its working groups in the preparation and conduct of their work, and also provides technical assistance to member states and other stakeholders. A comprehensive schedule of Commission and working group sessions has been planned for this year, as shown. As mentioned, UNCITRAL working groups develop texts and legal instruments for the Commission to consider adopting. In this regard, UNCITRAL does not handle state-to-state relationships like the World Trade Organization, but addresses cross-border transactions and disputes arising from those transactions, thereby comprising international private law. To this end, UNCITRAL texts focus on commercial entities, or in some instances, a commercial entity and a government. UNCITRAL has adopted a flexible and functional approach with respect to the techniques it uses to execute its mandate to modernize and harmonize international trade law. These techniques fall into 3 broad categories, which operate at different levels and involve different levels of compromise or acceptance of difference. That is, legislative, contractual, and explanatory. A convention or treaty is designed to unify law by establishing binding legal obligations. It is often used where the objective is to achieve a high degree of harmonization of law in the participating states, reducing the need for a party to undertake research of the law of another state party. To become a party to a convention, states are required formally to deposit a binding instrument of ratification or accession with the depository. For conventions to prepared by UNCITRAL, the depository is Secretary General of the United Nations. The entry into first of a convention is usually dependent upon the deposit of a minimum number of instruments of ratification. A model law is a legislative text that is recommended to states for enactment as part of their national law. It is an example of a text which is drafted to harmonize domestic law. A model law is an appropriate vehicle for modernization and harmonization of national laws when it is expected that states will wish or need to make adjustments to the text of the model to accommodate local requirements that vary from system to system, or where strict uniformity is not necessary or desirable. It is precisely this flexibility that makes a model law potentially easier to negotiate than a text containing obligations that cannot be altered. For a number of reasons, it is not always possible to draft specific provisions in a suitable or discrete form, such as a convention or a model law for incorporation into national legal systems. For example, national legal systems often use widely disparate legislative techniques and approaches for solving a given issue. States may not yet be ready to agree on a single approach or a common rule. There may not be consensus on the need to find a uniform solution to a particular issue, or there may be different levels of consensus on the key issues of a particular subject and how they should be addressed. In such cases, it may be appropriate to develop a set of principles or legislative recommendations rather than a uniform text. In order to advance the objective of harmonization and offer a legislative model, a legislative guide would provide a set of possible legislative solutions to certain issues. Harmonization of international trade law in practice requires that the laws concerned are interpreted in a uniform manner. Many UNCITRAL texts contain the principle that in interpreting the text concerned, judges and arbitrators should consider the international origin of the law and the need to promote uniformity in its application. In order to support consistency in decisions and orders on its text, UNCITRAL established a system in 1988 to collect and disseminate information on court decisions and arbitral awards relating to UNCITRAL texts, the case law on UNCITRAL texts known as CLOUT. Each case in CLOUT includes a short summary of the case, and these CLOUT abstracts are published in collections known as CLOUT issues in all 6 official UN languages, available for free and searchable on the UNCITRAL website shown here. To promote the use and adoption of UNCITRAL texts, in addition to national legislation reviews, the Secretariat undertakes 2 other main activities: the provision of technical assistance and capacity building, along with the collection and dissemination of information on developments in the field of international trade law. The core of the work undertaken by our office, the UNCITRAL Regional Center for Asia and the Pacific, lies here, focusing on jurisdictions and stakeholders in the Asia Pacific. RCAP is UNCITRAL's only regional center, opening our doors since 2012 with the support of the South Korean government and Hong Kong SCR China. RCAP comprises 5 staff members and 3 to 5 interns. Among our staff members are 2 legal experts seconded from the South Korean Ministry of Justice and Hong Kong SCR China Department of Justice. Since RCAP was established in 2012, the majority of Asia-Pacific jurisdictions under our coverage have adopted at least one UNCITRAL instrument, greatly contributing to legal harmonization. These actions cover a comprehensive span of UNCITRAL areas, ranging from dispute settlement to sale of goods, electronic commerce, and insolvency. UNCITRAL RCAP's technical assistance activities range from organizing briefing missions for government agencies to assisting international development agencies in using UNCITRAL texts in their law reform projects, to raise awareness of and familiarize public and private stakeholders with UNCITRAL texts and their use. In line with this mandate, we annually collaborate with governments, regional and international organizations, and numerous stakeholders to co-host a series of flagship events. The lineup of flagship events scheduled for the final quarter of this year is as shown. Finally, UNCITRAL RCAP invites you to subscribe to our mailing list via the QR code. Thanks again to UNPAD, Faculty of Law. I now pass the floor to the moderator.
Yeah, thank you, Mrs. Kim, for the presentation. And the second presentation from Ms. Athita. Athita Komindr.
Thank you.
Yeah.
Allow me some time to share my screen. So I hope everyone can see my slides well. So thank you again for inviting UNCITRAL RCAP to discuss the UNCITRAL arbitration framework. I will first provide an overview of the UNCITRAL arbitration instruments before delving into what was requested to be the main focal point, the UNCITRAL model law on international commercial arbitration and the UNCITRAL arbitration rule. Create a favorable environment for resolving disputes arising from cross-border transactions with the aim of developing a fair and efficient resolution system. This work contributes meaningfully to the achievement of Sustainable Development Goal 16, which is the promotion of access to justice and governance in accordance with the rule of law, and furthers the development of a mature, rule-based global commercial system. Dispute settlement topics covered by UNCITRAL include international commercial arbitration and mediation, online dispute resolution, and most recently, dispute resolution in the digital economy. Today, I will be focusing on arbitration, as my colleague, RCAP legal expert Tracy Choi, will be discussing mediation afterwards. The UNCITRAL arbitration framework comprises a wide spectrum of legal instruments, ranging from treaties, model laws, contractual texts for use by parties and institutions, and exploratory texts, as my colleague Hangyeol had just explained in her slide set. So some of the key UNCITRAL texts with regard to arbitration include the New York Convention, the UNCITRAL model law on international commercial arbitration, the UNCITRAL arbitration rules, and there are also other instruments assisting the implementation of the arbitration framework. For example, the notes on organizing arbitral proceedings and recommendations to assist arbitral institutions and other interested bodies with regard to arbitration under the UNCITRAL arbitration rules. All UNCITRAL instruments are available on the website in the 6 official languages of the United Nations: Arabic, Chinese, English, French, Russian, and Spanish. It might also be useful at this juncture to highlight to those less familiar with UNCITRAL what the Secretariat does not and cannot do as it goes beyond our mandate. So in sum, although UNCITRAL has prepared legal instruments, including those relating to international commercial arbitration and mediation, UNCITRAL does not offer legal advice in specific disputes nor recommend legal practitioners. UNCITRAL and its Secretariat do not administer arbitration or mediation proceedings or perform services related to individual proceedings, nor keep any list of potential arbitrators or mediators under the relevant UNCITRAL rules, nor act as appointing authority under the UNCITRAL arbitration and mediation rules. I say this because we receive questions on this all the time. There may be some users out there in the audience who are less familiar, so I just like to highlight that at this juncture. So a brief snapshot of the New York Convention, which I'm sure all the students here are really familiar with. So foremost among the advantages of arbitration is the greater certainty that parties can expect because of the well-established mechanism to enforce awards through the New York Convention, which UNCITRAL safeguards. It sets a maximum level of control at the recognition and enforcement stage. This principle is reflected in Article 3, which grants contracting states the discretion to determine the applicable rules for recognition and enforcement, so long as they do not impose substantially more onerous conditions or higher fees or charges on the recognition or enforcement of arbitral awards than are imposed on the recognition or enforcement of domestic arbitral awards. On the other hand, contracting states are free to apply more liberal rules than those set forth in the convention to facilitate recognition and enforcement to the greatest extent possible. The convention has near universal participation by 172 states, including Indonesia, with the latest being Timor-Leste, and provides common legislative standards for the recognition of arbitration agreements and court recognition and enforcement of foreign and non-domestic arbitral awards, which can be challenged only under very limited circumstances. The convention is an excellent example of advancing harmonization through uniform interpretation. The practices highlighted in the UNCITRAL Secretariat Guide on the Convention demonstrate that despite the diversity of the contracting states' legal systems, the interpretation and application of the Convention has been rather consistent and in conformity with the Convention's policy of favoring recognition and enforcement. Many contracting states, which first adhered to a more interventionist approach to international arbitration, have, in accordance with obligations undertaken under the Convention, moved towards a liberal regime that limits court control over the arbitral process. Turning now to the model law. The UNCITRAL Model Law on International Commercial Arbitration was adopted in 1985, and the amendments in 2006. The model law serves the purpose of establishing a unified legal framework for the fair and efficient settlement of disputes arising in international commercial relations. It is designed to assist states in reforming and modernizing their laws on arbitral procedure, so as to take into account the particular features and needs of international commercial arbitration. It reflects worldwide consensus on key aspects of international arbitration practice, having been accepted by states of all regions and the different legal or economic systems of the world. The UNCITRAL Model Law has its origins in the New York Convention, which is a widely recognized foundational instrument of international arbitration and requires courts of contracting states to give effect to an agreement to arbitrate when seized of an action in a matter covered by an arbitration agreement, and also to recognize and enforce awards made in other states, subject to specific limited exceptions. The New York Convention, however, does not deal with either the substantive or the procedural law of arbitration, areas which are left largely for national legislators. This is where the model law comes into play. The model law is a set of rules to be adopted by states in their domestic laws. It was developed to address considerable disparities in national laws on arbitration, and was based on findings that national laws are often particularly inappropriate for international cases. As a response to these inadequacies and disparities, the model law presents a special legal regime tailored to international commercial arbitration, without affecting any relevant treaty in force in the state adopting the model law. The model law is based on international expertise, consensus-based, and thus the risk of lacunae is minimized since we take our time to discuss these provisions. And the model law has also gained considerable success, as we will see on the next slide. The map shows the 86 states with a total of 119 jurisdictions that have adopted the model law so far. There are over 30 jurisdictions in the Asia Pacific, listed here for ease of reference. UNCITRAL RCAP, my office, plays an important role in the expansion of the model law, as it provides technical assistance to states with respect to the adoption and uniform interpretation of UNCITRAL texts. So as opposed to a convention, which is an instrument that is binding under international law on states and other entities with treaty-making capacity that choose to become a party to that instrument, a model law is created as a suggested pattern for lawmakers and national governments to consider adopting as part of their domestic legislation. The form of a model law was chosen as the vehicle for harmonization and modernization in view of the flexibility it gives to states in preparing new arbitration laws. Notwithstanding that flexibility, and in order to increase the likelihood of achieving a satisfactory degree of harmonization, states are encouraged to make as few changes as possible when incorporating the model law into their legal systems. Efforts to minimize variation from the text adopted by UNCITRAL are also expected to increase the visibility of harmonization, thus enhancing the confidence of foreign investors as the primary users of international arbitration in the reliability of arbitration law in the enacting state. There is no fixed criteria in considering whether a country has adopted the UNCITRAL model law on international commercial arbitration, but such jurisdiction has to include the key elements of the model law and not to go against its spirit and purpose. Now we turn to the key elements of the UNCITRAL model law, which covers all stages of the arbitral process from the arbitration agreement, the composition and jurisdiction of the arbitral tribunal, and the extent of court intervention through the recognition and enforcement of the arbitral award. The model law is based on key principles, which are the party autonomy, the limited intervention of courts in the arbitral proceedings, the competence of the tribunal to determine its own competence, the separability of the arbitration agreement from the contract in which it is contained, and the setting aside as a sole recourse against an arbitral award. The model law has 8 chapters addressing specific issues of international commercial arbitration, namely general rules, arbitration agreement, the composition of an arbitral tribunal, its jurisdiction, the conduct of proceedings, making of the award, recourse against it, and recognition and enforcement. The model law was designed with international commercial arbitration in mind. And at the same time, it offers a set of basic rules that are suitable for other types of arbitration. So the model law applies to international commercial arbitration, the terms of which are broadly defined in the text as agreed by the drafters. In sum, the model law characterizes an arbitration as international if the parties to an arbitration agreement have, at the time of the conclusion of that agreement, their places of business in different states. The term commercial is to be widely interpreted and includes matters arising out of relationships that might be described as commercial in nature, whether contractual or not, while the term arbitration covers any arbitration, whether or not administered by a permanent arbitral institution. With regards to the territorial scope of application, the model law as enacted in a given state applies only if the place of arbitration is in the territory of that state, with important exceptions to the effect that certain articles apply, irrespective of whether the place of arbitration is in the enacting state or elsewhere, or as the case may be, even before the place of arbitration is determined. So examples would include, for all you students out there, Articles 8.1 and 9, which deal with the recognition of arbitration agreements, including their compatibility with interim measures ordered by court. Article 17J on court-ordered interim measures. Articles 17H and I on the recognition and enforcement of interim measures ordered by an arbitral tribunal, and Articles 35 and 36 on the recognition and enforcement of arbitral awards. Another major feature of the model law is the delimitation of court assistance and supervision following the international trend in favor of limiting and clearly defining court involvement in international commercial arbitration, as per the intent of the parties to an arbitration agreement, preferring the finality and expediency of the arbitral process. Thus, the model law simply secures arbitration's advantages. The model law envisages court-only specific instances where national courts can intervene, for example, on issues of appointment of an arbitrator, jurisdiction of the arbitral tribunal, recognition of the arbitration agreement, setting aside of the arbitral award, and recognition and enforcement of interim measures. Chapter 2 of the model law deals with the arbitration agreement, including its recognition by courts. As you can see in the blue box, the arbitration agreement is defined as an agreement by the parties to submit to arbitration all or certain disputes that have arisen or may arise between them in respect of a defined legal relationship, whether contractual or not. The original 1985 version of the provision closely followed Article 2.2 of the New York Convention, requiring that an arbitration agreement be in writing. However, practitioners subsequently pointed out that in a number of situations, the drafting of a written document was impossible or impractical, and thus where the willingness of the parties to arbitrate was not in question, the validity of the arbitration agreement should be recognized. And in amending Article 7, the Commission adopted 2 options. The first option follows the New York Convention in requiring the written form of the arbitration agreement, but recognizes a record of the contents of the agreement in any form, including orally, as equivalent to traditional writing, as long as the content of the agreement is recorded. Reference is also made to the use of electronic communications, inspired by wording from the 1996 UNCITRAL Model Law on Electronic Commerce and the 2005 United Nations Convention on the Use of Electronic Communications in International Contracts. Now, the second approach defines the arbitration agreement in a manner that omits any form requirement. So no preference was expressed by the Commission in favor of either option 1 or 2, both of which are offered for enacting states to consider depending on their particular needs and by reference to the legal context in which the model law is enacted, including the general contract law of the enacting state. Both options are intended to preserve the enforceability of arbitration agreements under the New York Convention and establish a more favorable regime for the recognition and enforcement of arbitral awards than that provided under the Convention. Next, the model law addresses the complex relationship between the arbitration agreement and the resort to courts. So Article 8 is modeled on Article 2.3 of the New York Convention and basically obliges any court to refer the parties to arbitration if the court is seized with a claim on the same subject matter, unless it finds that the arbitration agreement is null and void, inoperative, or incapable of being performed. This provision, where adopted by a state enacting the model law, is by its nature binding only on the courts of that state. However, since Article 8 isn't limited in scope to agreements providing for arbitration to take place in the enacting state, it promotes the universal recognition and effect of international commercial arbitration agreements, thus enhancing harmonization of international commercial law. Article 9 of the model law expresses that any interim measures of protection that may be obtained from courts under their procedural law are compatible with an arbitration agreement. Chapter 3 of the model law on a tribunal's composition deals with appointments, challenges, termination of mandate, and replacement of an arbitrator. Most importantly, the chapter enshrines parties' freedom to determine, referring to arbitral rules or an ad hoc agreement, the procedure to be followed, subject to the fundamental requirements of fairness and justice. The model law also provides for assistance by courts or designated competent authorities should difficulties arise. In addition, to prevent dilatory tactics or short time periods are set, and decisions rendered by courts or other authorities on such matters are not subject to appeal. The next chapter, chapter 4, addresses a tribunal's competence to decide on its jurisdiction and power to order interim measures. So with regard to jurisdiction, Article 16 of the model law adopts the principle of competence, allowing the arbitral tribunal to rule on its own jurisdiction independently, including any objections with respect to the existence or validity of the arbitration agreement without having to resort to a court. Article 16 also adopts the principle of separability, meaning that an arbitration clause shall be treated as a separate agreement independent of the other terms of the contract. Consequently, a decision by the arbitral tribunal that the contract is null and void shall not entail the invalidity of the arbitration clause. The article also provides that any objections to jurisdiction should be made at the earliest possible time. The competence of the arbitral tribunal to rule on its own jurisdiction is not unlimited and thus subject to court control. In particular, where the arbitral tribunal rules as a preliminary question that it has jurisdiction, the law allows for immediate court control to avoid wasting time and money, with procedural safeguards built in to prevent or reduce the effect of diversionary tactics, such as a short time period for resort to court, court decision not appealable, and discretion of the arbitral tribunal to continue the proceedings and make an award while the matter is pending before the court. Next, the model law regulates tribunals' power to order interim measures and preliminary orders. In 5 consequent sections, the model law covers such different issues as definition of interim measures and the conditions for granting such measures, the application for and conditions for the granting of preliminary orders, rules applicable to both preliminary orders and interim measures, and court-ordered interim measures, entrusting courts with the same power of issuing an interim measure concerning arbitration proceedings. These sections were adopted and included in the law by the Commission in 2006. They replace Article 17 of the original 1985 version of the model law. And a notable innovation of the revision lies in the establishment in Section 4 of a regime for the recognition and enforcement of interim measures, which was modeled as appropriate on the regime for the recognition and enforcement of arbitral awards under Articles 35 and 36 of the model law. The next chapter provides for the legal framework for a fair and effective conduct of the arbitral proceedings. In particular, it establishes parties' fundamental procedural rights, rules of procedure, and empowers the arbitral tribunal to carry out its task in case of a party's default. Such provisions provide international commercial arbitration its necessary effectiveness within the limits of fundamental requirements of procedural justice. The model law guarantees the fundamental rights of parties to the dispute by ensuring that the parties shall be treated with equality and given a full opportunity of presenting their case. This general principle is reflected in numerous provisions, such as parties' general entitlement to oral hearings and provisions related to the evidence by an expert appointed by the arbitral tribunal, such that any expert report or evidentiary document on which the arbitral tribunal may rely in making its decision shall be communicated to the parties. The next subject is the determination of procedural rules. The model law guarantees the parties freedom to agree on the arbitral tribunal's procedure, thus enabling parties to select or tailor the rules according to their specific wishes and needs, which is of special importance in international cases and allows parties to bypass possibly conflicting domestic concepts. Should parties fail to agree on procedure, an arbitral tribunal still has the power to conduct the procedure in such a manner as it considers appropriate. Such discretion allows the tribunal to meet all needs of a particular case and select the most suitable procedure. Moreover, the model law guarantees that arbitral proceedings may be continued even if one of the parties is absent, but due notice has to be given. This provision is of utmost practical importance since it allows the tribunal to deal with parties that may be unwilling to cooperate or have little interest in expediting matters. Chapter 6 of the model law covers determination of the rules of law governing the substance of the dispute, making arbitral decisions, and the making of an arbitral award. First, the instrument covers rules on the determination of the rules of law applicable to the substance of a dispute. Under the model law, parties basically have the freedom to choose the applicable substantive law, such as national laws of different countries. In addition, by referring to the choice of rules of law instead of law, the model law broadens the range of options available to the parties as regards the designation of the law applicable to the substance of the dispute. For example, parties may agree on rules of law that have been elaborated by an international forum, but have not yet been incorporated into any national legal system. Thus, parties can choose an instrument such as the United Nations Convention on Contracts for the International Sale of Goods, or the CISG, as the body of substantive law governing the arbitration, without referring to the national law of any state party to that convention. In cases where parties have not chosen the applicable law, the tribunal is entrusted to apply the national law, determined by the conflict of laws rules it considers applicable. Next, the model law provides the tribunal with a procedure of making an award or other decisions. Thus, in the situation where the arbitral tribunal consists of more than one arbitrator, the decision or award shall be adopted by the majority of them. Parties can also entrust a presiding arbitrator to issue decisions on procedural issues, covering the determination of oral hearings, setting time limits, proceedings language, and expert appointments. The model law contains the specific requirements of the award, i.e., that it be made in writing, stating its date, the place of arbitration, and the reasons on which it is based, unless the parties have agreed otherwise. And the model law neither requires nor prohibits dissenting opinions. The 7th chapter of the model law deals with setting aside the arbitral award. The disparity found in national laws as regards the types of recourse against an arbitral award available to the parties presents a major difficulty in harmonizing international arbitration legislation. As such, the model law provides only one type of recourse, application for setting aside an award, which must be made within 3 months of receipt of the award and may only be made to a court in the state where the award was rendered, which is known as the seat of arbitration. The model law also provides an exhaustive list of the grounds on which an award may be set aside, which essentially mirrors that contained in Article 5 of the New York Convention, namely the grounds to set aside which are to be proven by one party, which are the arbitration agreement is invalid or parties lack the capacity to conclude it, party was unable to present its case or was not properly notified. An award deals with matters outside of an arbitration submission scope, where the conduct of proceedings or composition of the tribunal was contrary to parties' agreement or failing such agreement to the model law. And there are also the grounds to set aside that a court may consider of its own initiative, but can also be raised by one party, which are the subject matter of a dispute is not arbitrable or the award violates public policy. It is important to note that the model law does not preclude a party from seeking court control by way of defense and enforcement proceedings, as well as from appealing to an arbitral tribunal of the second instance if the parties have agreed on such a possibility. The last chapter of the model law deals with recognition and enforcement of awards. The underlying premise is uniform treatment of all awards, irrespective of country of origin. By treating awards rendered in international commercial arbitration in a uniform manner, irrespective of where they were made, the model law distinguishes between international and non-international awards based on substantive grounds rather than territorial borders. Moreover, based on these considerations and the desire of overcoming territorial restrictions, reciprocity is not included as a condition for recognition and enforcement. As per the blue box, an arbitral award shall be recognized as binding and enforced, subject to the provisions stipulated in the model law, which parallels the relevant recognition and enforcement provisions of the New York Convention discussed in the previous slide on setting aside the award. So turning now from the UNCITRAL model law to the UNCITRAL arbitration rules. While the model law was created as a suggested pattern for lawmakers and national governments to consider adopting as part of their domestic legislation, the UNCITRAL arbitration rules provide a comprehensive set of procedural rules upon which actual or potential parties to a dispute may agree for the conduct of arbitral proceedings arising out of their commercial relationship and are widely used in ad hoc arbitrations as well as institutional arbitrations. The UNCITRAL arbitration rules provide a comprehensive set of procedural rules upon which parties may agree for the conduct of arbitral proceedings, as mentioned, and the rules cover all aspects of the arbitral process, providing a model arbitration clause, setting out procedural rules regarding the appointment of arbitrators and the conduct of arbitral proceedings, and establishing rules in relation to the form, effect, and interpretation of the award. At present, there exist 4 different versions of the arbitration rules: the 1976 version, the 2010 revised version, the 2013 version, which incorporates the UNCITRAL rules on transparency for treaty-based investor-state arbitration, and the 2021 version, the most recent version, which incorporates the UNCITRAL expedited arbitration rules. So that version is circled there on your screen. The UNCITRAL arbitration rules were initially adopted in 1976 and have been used for the settlement of a broad range of disputes, including disputes between private commercial parties where no arbitral institution is involved, investor-state disputes, state-to-state disputes, and commercial disputes administered by arbitral institutions. Let's see. Right. So the UNCITRAL arbitration rules as revised in 2010 have been effective since 15 August 2010. The 43 articles are divided into 4 sections and cover all aspects of arbitration, including provisions dealing with multiple party arbitration and joinder, liability, and a procedure to object to experts appointed by the arbitral tribunal. The rules also aim to enhance procedural efficiency by including revised procedures for the replacement of an arbitrator, the requirement for reasonableness of cost, and a review mechanism regarding the costs of arbitration. They also include more detailed provisions on interim measures and an annex containing model arbitration clauses for contracts. The rules comprise 43 articles, which are divided into 4 sections as shown on your screen, and cover all aspects of arbitration, including the scope of application, effective date, notice and calculations of periods of time, the composition of the tribunal, the arbitral proceedings, the award, and also in the annex, which contains model arbitration clauses for contracts. With the adoption of the UNCITRAL rules on transparency in treaty-based investor-state arbitration, or the rules on transparency in 2013, a new Article 1, Paragraph 4 was added to the text of the arbitration rules as revised in 2010 to incorporate the rules on transparency for arbitration initiated pursuant to an investment treaty concluded on or after 1 April 2014. The transparency rules are a set of procedural rules that ensure public accessibility to treaty-based investor-state arbitration, the proceedings of which have traditionally been conducted behind closed doors. The new paragraph added to the UNCITRAL arbitration rules in 2013 provides for utmost clarity in relation to the application of the rules on transparency in investor-state arbitration initiated under the UNCITRAL arbitration rules. In all other respects, the 2013 UNCITRAL arbitration rules remain unchanged from the 2010 revised version. The UNCITRAL transparency standards also include the Mauritius Convention on Transparency, which aims at providing states and regional economic integration organizations with an efficient mechanism for making the rules on transparency applicable to investment treaties concluded before the UNCITRAL transparency rules entered into force on 1 April 2014. The convention thus supplements pre-existing investment treaties with respect to transparency-related obligations. Information to be made available to the public under the rules on transparency is published by a central repository, a function undertaken by the Secretary General of the United Nations through the UNCITRAL Secretariat via the link shown on your screen. With the adoption of the UNCITRAL expedited arbitration rules in 2021, a new Article 1, Paragraph 5 was added to the text of the arbitration rules to incorporate the expedited rules as an appendix to the UNCITRAL arbitration rules. The phrase, "where the parties so agree," in that paragraph emphasizes the need for the parties' express consent for the expedited rules to apply to the arbitration. The expedited rules balance the need for efficiency in the arbitral proceedings with the rights of the disputing parties to due process and fair treatment. Expedited arbitration is a streamlined and simplified procedure with a shortened time frame, which makes it possible for the parties to reach a final resolution of the dispute in a cost and time effective manner and providing them even more options with regard to dispute resolution. The expedited arbitration rules are not a standalone document. They are annexed to the UNCITRAL arbitration rules. Hence, they are to be read in conjunction with the UNCITRAL arbitration rules. Article 1 provides guidance on when the expedited rules apply. A footnote to Article 1 of the expedited rules identifies the articles in the UNCITRAL arbitration rules that do not apply to proceedings governed by the expedited rules, subject to party agreement otherwise. So when might expedited arbitration be a practical option for parties? So according to UNCITRAL's explanatory note to the UNCITRAL expedited arbitration rules, when referring their dispute to arbitration under the expedited rules, the parties and the arbitral tribunal should take into account the following elements, among others, when deciding whether expedited arbitration is suitable for the dispute. So there's the urgency of resolving the dispute, the complexity of the transactions and the number of parties involved, the anticipated complexity of the dispute, the anticipated amount of the dispute, the financial resources available to the party in proportion to the expected cost of the arbitration, the possibility of joinder or consolidation, and the likelihood of an award being rendered within the timeframes provided in Article 16, which is 6 months. But how is expedited arbitration different? So one of the first differences is a compressed timeline for rendering an award. In exceptional circumstances, the tribunal may extend the shortened deadline up to 9 months following the tribunal's constitution, but can only do so in exceptional circumstances and after inviting the parties to express their views. If the arbitral tribunal concludes that it is at risk of not rendering an award within 9 months from the date of the constitution of the tribunal, it shall propose a final extended time limit, state the reasons for the proposal, and invite the parties to express their views within a fixed period of time. The extension shall be adopted only if all parties express their agreement to the proposal within the fixed period of time. If there is no agreement to the extension, any party may make a request that the expedited rules no longer apply to the arbitration. And such approach was a compromise among the negotiating states when considering the expedited rules to ensure, on the one hand, that an expedited proceeding would be achieved through the application of the UNCITRAL expedited arbitration rules, and on the other hand, awards rendered through such proceedings were not susceptible to annulment and were enforceable in the end. So while shorter timeframes constitute one of the key characteristics of expedited arbitration, arbitral tribunals should endeavor to preserve the flexible nature of the proceedings and comply with due process requirements. Another difference is that the expedited rules default to a sole arbitrator. To facilitate the tribunal's constitution, the claimant must propose an arbitrator and appointing authority in its notice of arbitration. Lastly, the expedited rules provide that the arbitration might be conducted on the basis of documents and other materials only without conducting hearings. Article 15 clarifies the discretionary power of the tribunal with regard to the taking of evidence, including a reaffirmation of its power to reject a phase for the production of documents. These provisions entrust a tribunal with a robust mandate to balance expeditiousness and due process, thus contributing to legal certainty and mitigating risks at the enforcement stage. So that ends my very long presentation. I hope it suits the needs of the arbitration students here today. The UNCITRAL Regional Center also invites you to subscribe to our mailing list via the QR code, as we had previously mentioned. My colleague Tracy will be talking about how you can learn more about the UNCITRAL dispute settlement framework, including our arbitration instruments. And many thanks again to UNPAD colleagues and all supporters of this excellent event.
Yeah, thank you for the comprehensive presentation, Ms. Athita. And we move to Ms. Tracy Choi. The screen is yours. Still mute, Ms. Tracy?
I'm sorry, can you hear me now?
Yes, I can hear you now.
Yes. So thank you so much for organizing today's event. I'm Tracy Choi, legal expert from UNCITRAL RCAP, and this is my pleasure to provide an overview of UNCITRAL's mediation framework to all of you today. First, here is a general overview of the UNCITRAL instruments on mediation. UNCITRAL has long recognized the value of mediation, previously referred to as conciliation, as a method of amicably settling disputes arising in the context of international commercial relations. With the understanding that there is a need for unification of mediation regulations, UNCITRAL adopted in 1980 the UNCITRAL conciliation rules, which were the first international steps taken to develop rules on mediation. The rules are a set of procedural rules that can be used by parties without an institution administering mediation. As such, parties are free to modify and adapt the rules as they wish and tailor mediation to their needs and expectations. As it became apparent that contractual solutions alone were not sufficient to meet the parties' need, UNCITRAL developed a model legislative framework on mediation and adopted in 2002 the Model Law on International Commercial Conciliation. The 2002 Model Law provided a sound legislative basis on the procedural aspects of mediation, but it did not contain uniform rules on the enforcement of settlement agreements resulting from mediation, which was largely left to each state. The use of mediation in cross-border disputes was therefore challenged for the lack of an efficient and harmonized framework for cross-border enforcement, unlike the arbitration, which benefits from the nearly universal New York Convention. In response to this need, UNCITRAL developed both a model legislative test and a convention on the enforcement of international commercial settlement agreements resulting from mediation, without expressing any preference on the type of instrument to be adopted by the states. These instruments, namely the Singapore Convention on Mediation and the Model Law on Mediation, were both adopted in 2018. Furthermore, states are granted the flexibility to adopt either the convention or the model law as a standalone test, or both as complementary instruments of a comprehensive legal framework on mediation. And this legal framework was further enhanced with the adoption of 4 tests, namely the mediation rules, which updates the 1980 conciliation rules, the notes on mediation, the guide to enactment and use of UNCITRAL model law on mediation, and the recommendations to assist mediation centers and other interested bodies with regard to mediation under the UNCITRAL mediation rules. Turning to the Singapore Convention on Mediation, there were 46 original signatories when the convention opened for signing in Singapore on the 7th of August 2019, making the convention one of the most successful developed by UNCITRAL in terms of signatories obtained on the opening day. By way of comparison, the New York Convention had only 10 initial signatories in June 1958. The convention entered into force on 12 September 2020, 6 months after its 3rd ratification, and impressively, only about 1 year after the convention opened for signing. As of the 4th of May this year, the convention has 56 signatories, including 11 parties. The United Kingdom is the country that most recently signed the convention on the 3rd of May 2023. The current 56 signatories already represent over half of the global population and include the world's 2 largest economies, China and United States. Approximately half of the signatories are in the Asia Pacific. In particular, half of the ASEAN member states have also signed the convention. The increasing signatories demonstrates how the convention is attractive to states with different legal, social, and economic systems. As mentioned, the Singapore Convention on Mediation was designed to address the lack of effective means to enforce cross-border commercial mediated settlement agreements by establishing a harmonized legal framework for the right to invoke and enforce settlement agreements. To imagine what dispute settlement would look like without the convention, I will describe several scenarios. Some states, without special provisions on the enforceability of such settlements, would instead apply general contract law. Others may resort to judicial enforcement. That is, settlement agreements must first be approved by relevant courts and then enforced as an order thereof. And there are other methods states can and have adopted for the enforcement of mediated settlement agreements. With the convention in force, a disputing party can enforce the international settlement agreement directly in a state by supplying to the relevant competent authority, first, the settlement agreement signed by the parties, and second, evidence that the agreement results from mediation. This creates legal certainty and predictability, which are conducive to business, foreign investment, and cross-border trade. The convention is particularly useful for MSMEs, which are vulnerable to escalating litigation and transaction costs from commercial disputes due to their limited financial strength. I will now describe the key provisions of the Singapore Convention on Mediation. Article 1, read with the definitions in Article 2, sets out its scope of application. Namely, it applies to international agreements resulting from mediation, concluded in writing by parties to resolve a commercial dispute. The settlement agreement must be international in character at the time of its conclusion. That is, at least two parties to the agreement have their place of business in different states, or the state in which the parties have their place of business is different from either the state in which a substantial part of the obligation under the agreement is performed, or the state in which the subject matter of the agreement is most closely connected. Disputes arising from consumer, personal, family, or household purposes, settlement agreements which have been approved or concluded by a court and are enforceable as such, and arbitral awards are all excluded from the scope of the convention. Article 2, the definitions, also includes other important terms in the convention. First, it explains the term place of business. If a party has more than one place of business, the relevant place of business is that which has the closest relationship to the dispute resolved by the settlement agreement, considering the circumstances known to or contemplated by the parties at the time of the conclusion of the agreement. If a party does not have a place of business, that party's habitual residence shall be referred to. Second, a settlement agreement is in writing if its content is recorded in any form. If it is in electronic form, this requirement is satisfied, so long as the information contained therein is accessible and usable for future reference. Third, mediation is defined as the process whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a mediator who lacks the authority to impose a solution upon the parties. The mediator's inability to impose a binding award is what differentiates mediation from arbitration. Article 3 sets out the general principles which underpin the core obligations of the parties to the convention. First, the parties are obligated to enforce mediated settlement agreements in accordance with the convention. Second, a party to the convention shall allow a disputing party to invoke the settlement agreement as proof that a matter has already been resolved. Article 4 provides that necessary formal and evidential requirements for a party to rely on a settlement agreement. For example, the document must be signed by the parties to ensure that the document represents a consensual agreement. Article 5 sets out the limited grounds for a competent authority of a party to the convention to refuse to grant relief, such as that a party to the settlement was under some form of incapacity, if granting the relief would be contrary to the enforcing state's public policy, or if there has been a serious breach of mediator standards. Finally, Article 8 details the process by which parties to the convention may make reservations. Additionally, parties are entitled to make or withdraw a reservation at any time. A first reservation permits a party to the convention to exclude from the application of the convention settlement agreements to which it is a party, or to which any governmental agencies or any person acting on behalf of a governmental agency is a party, to the extent specified in the declaration. A second reservation permits a party to the convention to declare that it will apply the convention only to the extent that the disputing parties have agreed to its application. I will now turn to the 2018 model law. Its purpose is to assist states in reforming and modernizing their laws on mediation procedure. Specifically, the model law contains definitions, procedures, and guidelines based on the importance of party control over the process and outcome. It strives to protect the integrity of the mediation process, while allowing parties maximum flexibility to preserve party autonomy. The model law consists of 3 sections and 20 articles. Section 1 contains the general provisions. Article 1 on scope provides that the test applies to international commercial mediation and international settlement agreement. Section 2 covers the mediation process and is based on the 2002 model law. The conduct of mediation is tackled in Article 7. It emphasizes the parties' autonomy in setting out the manner of procedure they deemed most appropriate. Absent the parties' agreement, the mediator maintains discretion over procedural aspects so long as fair treatment of the parties is preserved. Article 10 sets out the matter of confidentiality. Unless the parties agree otherwise, all information relating to the mediation proceedings shall be kept confidential, except where disclosure is legally required for purposes of implementation or enforcement of the settlement agreement. Article 14 limits the freedom to initiate arbitral or judicial proceedings. This protects the mediation process by barring the commencement of legal processes, which may obstruct the conclusion of an otherwise proper settlement. And Article 15 codifies the binding and enforceable nature of settlement agreements. Section 3 of the model law focuses on the outcome of mediation, namely the international settlement agreement. Notably, this section was drafted in parallel and is therefore consistent with the Singapore Convention on Mediation to accommodate the different levels of experience with mediation in different jurisdictions. This section is also the key difference between the 2018 and 2002 model laws. Article 16 specifies the model law's scope of application, specifically to written international agreements resulting from mediation which resolve a commercial dispute. Article 17 outlines the state's obligations to give legal force to settlement agreements and the disputing parties' right to invoke the agreement as a defense against claims. The requirements for reliance on a settlement agreement are detailed in Article 18. For the denial of relief by a competent authority are set out in Article 19. For example, in capacity of a party, the specified obligations have already been performed, or the grant of relief will frustrate the purpose of the agreement. The grounds for refusal are stated in general and exhaustive terms, giving the competent authority flexibility and discretion in interpretation and application. Finally, Article 20 provides that the competent authority has the discretion power to adjourn its decision if an application or claim relating to a settlement agreement has been made to a court, arbitral tribunal, or other competent authority, which might affect the process. UNCITRAL adopted the mediation rules in recognition of mediation's value as an amicable method of dispute resolution, particularly in the context of international commercial relations. These rules, which amended the 1980 conciliation rules, are a set of internationally harmonized procedural rules for the conduct of mediation proceedings. The rules also notably align with the provisions of both the Singapore Convention on Mediation and the 2018 model law. The articles of the rules are modeled after the model law, except for Articles 1, 11, and 13. Under Article 1, the applicability of the rules is subject to the parties' agreement to submit to mediation under the rules. The parties shall also be presumed to have referred to the rules in effect on the date of commencement of the mediation, unless they expressly refer to a particular version of the rules. And where the rules conflict with the law applicable to the mediation, from which the parties cannot derogate, the law shall prevail over the rules. Article 11 provides that the parties and the mediator should agree on the method for fixing the cost as early as possible. And Article 13 provides that, except in cases of intentional wrongdoing, the parties waive any claim against the mediator based on any act or omission in connection with the mediation. This article is modeled after Article 16 of the UNCITRAL arbitration rules. The last instrument I will talk about is the notes on mediation, which were prepared with a focus on international mediation. This is an explanatory test which was intended to be used in a general and universal manner by mediation practitioners and disputing parties. Given the flexibility that characterizes mediation, procedural practices, including styles and methods, to foster a settlement may vary. Each approach has its own merits. Therefore, the notes do not seek to promote a specific or particular practice. Instead, it seeks to assist parties to better understand mediation, including the wide and flexible range of possible outcomes. Parties and mediators, at their discretion and to the extent they see fit. Moreover, the notes do not impose any legally binding obligations on the parties or the mediators, and are not suitable to be used as mediation rules. So this is the end of my presentation on UNCITRAL's mediation framework. I will move on to talk about UNCITRAL's e-modules and the internship program. I will open another PowerPoint slides. Yes, so I'm going to talk about UNCITRAL's e-modules and RCAP's internship program. After my introduction of the internship program, two of our current interns, Ms. Chiu Shi and Ms. Ksenia, will share their first-hand internship experience. The UNCITRAL e-learning program was conceived as a tool to raise awareness of UNCITRAL, its mandate and its work, for all audiences and as a capacity-building tool. It is, in particular, intended for prospective UNCITRAL delegates, representatives of permanent missions, government officials, and policymakers dealing with UNCITRAL matters who may request technical assistance and capacity-building support from the Secretariat. It is also intended to complement UNCITRAL capacity building and awareness-raising activities by allowing deeper levels of discussion of UNCITRAL subjects and tasks between participants and those leading these activities. It's also suitable for those who would like to discover international commercial law and UNCITRAL's achievements in this field, or to deepen a broad overall understanding of international commercial law, comprising law students and new generations of legal practitioners. The program therefore sits squarely within the Secretariat's objective for its non-legislative activities to explain UNCITRAL's tests, their benefits, and usefulness to the attention of both those already engaged with UNCITRAL and those interested in commercial law reform in the broader context. On UNCITRAL's website, there are currently 4 online courses, as you may see on the right-hand side of the slide. The course on Introduction to UNCITRAL is currently available in both English and Chinese, while the remaining 3 courses are only available in English at the moment, but translation into Chinese is in the pipeline. The courses may be translated into other official United Nations language as resources allow in the future. These interactive self-paced courses are free, and participants may download a certificate upon completion. So I will briefly describe each online course. The first course is Introduction to UNCITRAL. It was first launched in July 2021. It aims at improving knowledge of UNCITRAL's role in reducing the legal obstacles to the flow of international trade. UNCITRAL plays an important role in developing a legal framework for the facilitation of international trade because of its mandate to prepare and promote the use and adoption of legislative and non-legislative instruments in a number of key areas. Much of the complex network of international legal norms and agreements that affects today's commercial arrangements has been reached through long and detailed consultations and deliberations in UNCITRAL. The course comprises 3 parts: an introduction to harmonized commercial law and its relevance for economic development, the origin, organization, and methods of work of UNCITRAL, and UNCITRAL's contribution to sustainable development. The second course is UNCITRAL Test on Public Procurement and Public-Private Partnerships. It provides an overview of UNCITRAL tests on public procurement and public-private partnerships, PPPs, and how they contribute to sustainable development goals. The course allows participants to understand the policy choices and principles implemented in UNCITRAL tests on public procurement and PPPs. The course contains 2 parts. The first one addresses public procurement and is centered on UNCITRAL model law on public procurement. The second one addresses PPPs and is based on the UNCITRAL legislative guide on public-private partnerships and associated model legislative provisions, and covers how to ensure that they can deliver and operate infrastructure for the benefits of states and citizens. The course on UNCITRAL International Commercial Arbitration introduces participants to the UNCITRAL framework on international commercial arbitration. Following a short general introduction on the basis of international commercial arbitration, the module will focus on UNCITRAL legislative instruments, treaties, model laws, and contractual rules, governing procedural aspects of arbitration with special attention paid to New York Convention, the UNCITRAL model law on international commercial arbitration, as well as the UNCITRAL arbitration rules. The fourth clause is the UNCITRAL mediation framework. It addresses to those interested in learning more about the UNCITRAL mediation framework. The course starts with an introduction to the increasing use of mediation in international commercial disputes, and also an overview of the work of UNCITRAL on mediation. Government officials and those engaged in commercial law reform at national level may be particularly interested in learning more on how UNCITRAL mediation instruments, particularly the Singapore Convention on Mediation and the 2018 Model Law on International Commercial Mediation, enhance access to justice for all by offering an alternative and easily accessible method of dispute resolution. Those in the private sector may be interested in learning more about UNCITRAL mediation rules and processes that could be adopted as contractual solutions. The course may also be interested to other actors, such as individuals from professional bodies, non-governmental organizations active in international trade, training institutions involved in international trade law and alternative dispute resolution, And last but not least, students who want to have a better understanding of the UNCITRAL instruments. So now I'm going to talk about the UNCITRAL RCAP internship program. UNCITRAL headquarters in Vienna, Austria, and UNCITRAL RCAP in Incheon, Republic of Korea, offer an internship program. The internship program is designed to give students the opportunities to become familiar with the work of UNCITRAL and to increase their knowledge of specific areas in the field of international trade law. Interns are selected by the UNCITRAL Secretariat and RCAP directly from among candidates who applied to a job opening posted at the United Nations career portal, as you can see on the slide. The Secretariat, in selecting interns, keeps in mind the needs of UNCITRAL and its Secretariat at any given period of time, in particular the need to maintain the UNCITRAL website in the 6 official languages of the United Nations. The Secretariat aims to balance gender and geographical representation. The objective of the internship is to provide training to the interns on the work of UNCITRAL while assisting RCAP staff with a wide range of projects. During the internship, the intern will gain experience in international trade law. Specific assignments during the internship include assisting in regional activities like the present AP Days event, comparative legal analysis in the Asia-Pacific region, regional research of case law on UNCITRAL tests, national legislation, and legal developments. Assisting with preparing publicity materials for UNCITRAL webpage, email blasts, and social media platforms, including Facebook, LinkedIn, and Twitter, and also other ad hoc legal and administrative assignments from time to time. I will briefly elaborate a bit on the qualification requirements for the internship program. On the education, applicants must be enrolled in or have completed either a graduate school program or the final academic year of a first university degree program. It is desirable that your field of study is closely related to private international law or UNCITRAL's work. Be computer literate in standard software applications, such as Microsoft Word, Excel, PowerPoint, etc., and also be able to conduct research on the internet. Have demonstrated keen interest in the work of United Nations and UNCITRAL, and the ability to successfully interact with individuals of different cultural backgrounds and beliefs. No working experience is required to apply for the internship program. Your training, education, advanced coursework, or skills should benefit the United Nations during your internship. Proficiency in oral and written English is required, and knowledge of another United Nations official language, such as namely Arabic, Chinese, French, Russian, or Spanish, as well as regional languages such as Japanese, Korean, or others, would be an advantage. The internship positions are for a minimum duration of 2 months and a maximum duration of 6 months. Internships are unpaid and full-time. Interns at RCAP work 5 days per week under the direct supervision of RCAP professional staff. There are internship application opportunities twice a year. The application periods usually start in December and June. The last round of applications closed in February 2023, so interested candidates should keep an eye on the United Nations Careers webpage for the next round of applications, very likely in June, so next month. UNCITRAL will also share information via Facebook, LinkedIn, and RCAP's mailing list. At RCAP, we have hosted successively diverse interns, both in person and remotely from all corners of the world. So here are some of the moments captured with our past interns. As Korea is returning to normalcy, interns will be invited to work at RCAP's office and participate in in-person activities in Korea. remote internship also remained an option. For those interested in the internship programs, we invite you to subscribe to our mailing list so you can receive up-to-date information on the internship application opportunities. Thanks, and I would now pass the floor to our interns for sharing of their internship experience. May I invite our intern Choi?
Yeah, thank you, Tracy. Ladies and gentlemen, good afternoon. It is my great honor today to have this opportunity to share my internship experience and reflections at RCAP with all of you. As you remember, in my first week at RCAP, I quickly participated in the AP Day event with Wuhan University. And now, as I become more familiar and professional with my work, I have been given the opportunity to share at the AP Day, which is truly meaningful to me. Firstly, allow me to introduce myself. My name is Choi Yan, and I'm currently a PhD student at China University of Political Science and Law, majoring in international law, and I will be graduate this June. I was also a visiting scholar at the University of California, Davis. Before that, I obtained a master's degree in international law from the University of Bristol in United Kingdom, and a bachelor degree in law from China University of Political Science and Law. So as you can see, in my academic research experience over the past 10 years, my main focus has always been international law, but this did not stop me from working on trade law related tasks at RCAP, and I will mention this point later. And now I would like to share you some reasons why I chose to apply for an internship at RCAP. I had not researched deep into the content of international trade law before. I had been involved in topics related to international arbitration while writing my master and doctoral degree. So I gained the interest in international trade law, in particular in the New York Convention and arbitration in investor state dispute settlement. Through the process of studying relevant legal instruments, I realized the outstanding in promoting international trade law. So in addition, working at UN has always been my dream. Years of studying international law made me particularly eager to join this remarkable international organization, to understand how it operates and how it provides and support and assistance to the world, and how it affects the world. Besides, during my experience living in countries like the United Kingdom, United States, and New Zealand, I realized the difference between international trade in Asia-Pacific region and the Europe and American regions. Therefore, as an Asian who deeply loves the region I live in, I'm very willing to contribute to the development of trade law in this region. Therefore, when I came across the internship chance for the UNCITRAL RCAP, I immediately completed the application, and 2 months later, I received the surprising offer. On February 27, 2023, I began my internship here. Due to various reasons, I chose to do my internship remotely, which was also my first internship experience in my life. Therefore, it made me a little nervous at first. However, soon, this tension disappeared. It was because the welcome and guidelines email sent by Athita before my internship began, the first day's warm online intern meeting, and the great help given by my colleagues, and the wonderful online collaboration with my coworkers. These all made me feel like I was working on site, which undoubtedly helped me to adapt and gradually enjoyed the internship. Therefore, I would like to share another important point with you. Please do not hesitate to apply for this internship due to limitations, because of the experience of remote work is not less than that in on-site work. Not only can you participate in various tasks and gain unique experience, but you can also meet many like-minded friends. Time difference will not be a problem either. Although I greet my colleagues in France and India with good morning and noon and in afternoon, it does not affect our smooth collaboration in completing assignments. The only regret is that I can only participate in my colleagues' gathering through photos and can only take screenshots instead of taking group photos with them. Lastly, I want to share my work at RCAP. This is a question that many people, including myself, have been curious about. Faced with such a great organization, I feel really nervous and worried about my abilities. This was also why I did not have the encourage to apply the internship during my undergraduate and master studies. However, after 2.5 months of work, I can now tell you that while having a suitable professional background and skills is undoubtedly one of the most important requirements for working here, but a strong interest and learning ability are equally important. As I mentioned before, although my research focus over the years was not on trade law, my understanding and basic research approach in this field allowed me to quickly adapt to the current work and even experience a new sense of joy, expanding my knowledge and research areas. UNCITRAL provides detailed trade law related documents, as well as free online courses prepared by us, just as Athita and Tracy mentioned in their parts. So you can get further understanding of trade law and enhance your confidence through these resources. Additionally, our legal experts, Hangyeol and Tracy, provide valuable advice and they are always willing to help. As a result, I have not only avoided difficulties in my work, but felt my own progress. The assignments here are also amazing. Recently, I have been involved in an incredible project of assigning a country in need by drafting a legal policy document. This might be a unique experience within only an organization like the United Nations. Through this process, I have experienced the joy in using my skills as an international law student to contribute to the world, while also gaining comprehensive improvements in my professional field. In addition, we also engage in various interesting assignments. For example, today's AP Day event, which involves extension collaboration with universities and institutions in Asian Pacific region, participating in different types of international conferences, organizing and analyzing trade law related publications, cases, and news. Through this series of exercises, although I'm still not an expert in the field of trade law, I have developed a deeper understanding and insight into international trade law, which is really beneficial for my future research career. Therefore, I believe joining RCAP is an excellent learning opportunity. It provides significant assistance not only in terms of legal knowledge, but also in areas of such as writing skills. Additionally, through other tasks, for example, attending international conferences and listening to experts from different fields have broadened my horizons and provided me with highly effective guidance. It is evident that this internship has expanded my vision, allowing me to see the landscapes I have never seen before. In conclusion, my internship experience at RCAP has been highly satisfying and fulfilling for me. Therefore, I strongly recommend you to apply for this internship since I'm confidently saying that you will not regret it. That concludes my speech for today. And sorry, I was a little nervous. Thank you for listening. And now, ladies and gentlemen, I would like you to welcome my colleague Sania to share her experience and idea. Sania, the floor is yours now.
Hello, everyone. I also thank you so much for the opportunity to share my internship experience at the event. So my name is Ksenia Nevzorova, and I'm currently undergoing my internship at the UNCITRAL RCAP located in South Korea, Incheon. Since RCAP provides opportunity for a hybrid internship, I'm also doing my master's degree at the same moment in the Seoul National University. So I believe that these home office arrangements provide a really great opportunity for interns to have more flexibility and the option to work remotely and to be productive both in your studies and at work. So for now, it's been over a month since I joined RCAP, and I'll share my experience of what opportunities interns are normally offered during the internship. So first of all, an internship offered a unique opportunity to obtain practical skills and inside look of the UNCITRAL system. Interns are normally involved in day-to-day tasks, but are also entrusted with specific longer and shorter-term projects. You'll be also given many assignments where you have to research and learn a lot of things. So it will be basically learning from working experience, which will make you more competent in the area of your interest and in legal sphere in general. Perhaps the most exciting part for me of being an UNCITRAL CAP intern is, I think, the depth of experience that you're surrounded with. So you will be able to learn from your colleagues who are very accomplished in the field, and they will very friendly and gladly teach you the skills and the knowledge useful for your future career path. Another noteworthy part is a great opportunity for networking. You'll be visiting different events and conferences on behalf of the RCAP to attend the meetings and collect the relevant information and material. Through this opportunity, interns can sharpen their knowledge in the field, gain the ideas and the best practices, learn about the latest innovations and insights, and also meet the influencers and industry experts face to face. So, for example, last week we were given the opportunity to attend the Asian Development Bank annual meeting that was held in South Korea this year. This was a truly lifetime experience, I can say. And by attending these events, interns can learn from the seniors and build valuable relationships. So I think to sum up my speech, I believe that this experience as an intern has altered my life for the better. Reflecting on my own internship experience, I think that it has definitely proved valuable in advancing my professional career. And I believe it also created long-lasting network relationships that in turn deepened and improved my personal development as well. So I hope my experience will help you to make the decision towards applying for the RCAP internship and experience the great opportunities provided here. Thank you. And I will pass the turn to Ms. Tracy.
Yes, thank you so much for Choi and Xenia's very interesting and insightful sharing. I hope students will be interested, and we really look forward to receiving applications from students in the next round's application. May I pass the floor back to the university? Thank you.
Thank you very much. How interesting. Thank you, Ms. Quisi Yang. Hard for me to spell your name in Chinese style. I'm so sorry. And also, Xenia, thank you for sharing. And thank you very much for our speaker. It's very insightful and comprehensive presentation. UNCITRAL for Indonesia, especially the product from UNCITRAL can be a reference for us and finding both international and regional rules to make rules and policy regarding e-commerce, arbitration, PPP, and other product transnational business law. And finally, we are moved to discussion session. In this session in 10 minutes, and we invite the participant to join with this discussion session. Yeah, please, the student and all participants can give the question directly by raise hand feature or chat box. Yeah, maybe the first question comes from chat box. Yeah, for the first question come from Mr. Maralda. For Mr. Maralda, could you please give the question directly?
Yeah, sure. Hi, I'm Maralda Khairupan. I have typed in the chat box my question, but let me repeat the question. So it's about the New York Convention. So basically the Article 5 and 6 of the New York Convention is also stipulated in the model law, if I'm not mistaken, that basically an enforcement and recognition of an international arbitration award can be refused by the request of the party against whom the award is invoked. So my question is such a refusal, is such request can be considered as a legal action or remedy? And if yes, what country, to your knowledge, or countries who have applied such concept in their legislation, for example. And lastly, whether the remedy can be considered as something that can weaken the goal of making or sustaining a country as a arbitration-friendly country. I think that's my question. Thank you so much.
Thank you, Mr. Maralda. Maybe Athita.
Thank you. Yeah, thank you for the question. I was actually hoping for questions from students because it's an academic event, but I guess everyone here is a student of arbitration, so to speak, even if it's learning by practice. So I think like for a more comprehensive overview of the issues that the individual has raised with regards to the New York Convention, I would direct people to the Secretariat Guide on the New York Convention. I have placed a link to that document in the chat box. And also, if you're interested in seeing how other jurisdictions have uniformly interpreted various provisions of UNCITRAL instruments, I would also direct you to the CLOUT, Case Law and UNCITRAL Text Database. All of these resources are freely available in the 6 United Nations official languages online. I've put the various links in the chat box. So I think I would direct our questions, the questions to those resources first, and maybe prioritize any questions that the students have about our work, the internship program here in the next 10 minutes. Also, for those learning more about our instruments on arbitration and mediation, Tracy had already mentioned the e-modules, so she will put in the chat box a link to the e-modules there, so you can also look at those. I think the arbitration one is pretty comprehensive. It takes about, I don't know, 2 hours, 2 hours and a half to complete. So I would direct people with questions on these like, I guess, like interpretive issues to those resources. Thank you.
Thank you, Athita, for the answer. It's very interesting answer. And maybe the next question, raise hand Arifania Shafa, please.
Sure. Thank you, Ms. Helita, for the opportunity. Also, a big thank you for all the honorable speakers and all lecturers. So my name is Arifania. I'm a student in Universitas Padjadjaran. So actually, I would like to ask a question. For me, it's like a basic question, basic theory of arbitration rules, but I'm really curious about it. So Ms. Athita, if I'm not mistaken, earlier presented about the expedited rules of arbitration. And if I'm not mistaken, this expedited rules of arbitration is like additional rules of arbitration. It is not like original rules in that arbitration rules. It is like additional rules of that arbitration, if I'm not mistaken. So is there any originally reason about the existing of this expedited rules of arbitration? And based on your experiences, is there any kind of cases which is only have to do with these expedited rules rather than common or usual arbitration rules? So I think that's all my question. Thank you.
Thank you very much, Arivania. Did I get your name correct? For the interesting and I think fundamental question. So UNCITRAL instruments are demand driven by states who are stakeholders, along with practitioners and international organizations and other institutional bodies that participate in UNCITRAL meetings through the working groups there. So when there is an appetite for a particular set of harmonized rules, then that will be brought for states to consider and then come up with the draft and then adopt. So that is where the expedited rules originated from. I think prior to the adoption of the UNCITRAL expedited rules, there are already different forms of expedited rules that were institution driven. So a particular arbitration center might have expedited rules or things like that. But then because stakeholders and governments had the need, they felt that there was a need for a global set of rules that could be uniformly adopted, especially via UNCITRAL, then this instrument was then adopted. Your understanding is perfectly correct in that they do not stand alone. They do not stand alone. They're part of the UNCITRAL arbitration rules, the edition of 2021. And your other question was, whether there is any case law yet. No, not yet. They're very new, but because the Secretariat is not able to monitor all the developments across the world, if any of you come across cases interpreting UNCITRAL instruments, in particular the UNCITRAL expedited rules, please feel free to send them along to us. We actually we take on contributions from voluntary contributors for the case law and UNCITRAL text database. So I know sometimes students come across this, our students who intern with us come across this sometimes. And then if the issue is something new or something very interesting, or especially from a jurisdiction that might not have clout cases, such as Indonesia, which doesn't have any yet, we would really be keen to include them in our digital database. So thank you for the question. Yeah.
Thank you.
Yes, thank you, Arifania and Ms. Athita. Next question come from Ahmad Sharif. Yeah, please. For
Okay.
Ahmad Sharif.
Am I clear? Yes.
Yes, I can hear you.
Thank you for the opportunity, Dr. Athita, and all the lecturer and the speakers. So my name is Ahmad Sharif, and I would like to inquire about the implementation of arbitration that has been regulated in the UNCITRAL legal instrument. So in today's technologically advanced world, as we know, what challenge may arise in implementing the UNCITRAL instrument, and how can they be overcome to ensure its successful adoption and use in cross-border disputes? And additionally, does artificial intelligence pose as a challenge or as an opportunity for the implementation of arbitration? Maybe that's from. Thank you.
Okay, so the adoption of the UNCITRAL model law, is that right? You're talking about the model law. States adopt the model law. So for that, I think it depends on the state as to whether it wants to adopt it or not. And how it would be adopted. Because the model law is just that, a model, states are free to derogate from those provisions according to their domestic needs. However, because these model laws are actually agreed globally, right? They're adopted by the Commission. The UNCITRAL would strongly encourage that the model laws be adopted within their original form. With regards, then there are the arbitration rules. So today I talked about the model laws that states adopt, and then the arbitration rules, which are for parties to adopt or institutions to adopt and administer. So those are very successful. Both the model law and the arbitration rules are very successful. Again, they are there for parties and institutions to use, depending on how they would like to use it. But of course, we would recommend that they be adopted in whole. If there are any differences, for example, especially in the UNCITRAL arbitration rules, then an institution publishing those rules with derogations might want to indicate at the beginning where the differences are from. So some differences are needed, for example, administrative costs and things like that which depends on the tribunal, but it's always good for the end users, the commercial clients in particular, to know where the differences are from, because they would think that if an institution promotes itself as saying that it administers UNCITRAL arbitration rules, then the rules would also be true to form. So I hope that answers your question. With regards to AI, that's an interesting question. Currently, UNCITRAL is looking, we have some exploratory work on dispute resolution in the digital economy, which also covers the issue of AI. Now, seeing that we're kind of a gender balanced audience here, I note that part of our exploratory work is looking at the potential gender bias in AI, which is sometimes based on stereotypes, and how that would affect dispute resolution in the digital economy. So I think that answers part of your question. Hope that works. Thank you.
Thank you, Ms.
Thank
Athita.
you very much, Ahmad Sharif and Ms. Athita. The next question from Sandy Okta. Yeah, Sandy Okta, please. Screen is yours.
Thank you to Madam Halita and the honorable speakers for the insightful explanation about UNCITRAL, particularly to the model law in international arbitrations and international commercial mediations. So I read the UNCITRAL model law to international commercial arbitration. Before that, I want to clarify: did I am audible? Am I audible? Am I audible?
Your bad connection.
Yeah.
Can you repeat the question?
Okay. Am I audible right now?
Yeah.
Okay. I read the UNCITRAL model law on international commercial arbitration, particularly in Article 34 and 36 regarding setting aside the award and recognition and enforcement of the award. While I read in Article 34 and 36 did not regulate the threshold of public policy that may challenge the recognition and enforcement of the award. Under UNCITRAL model law on international commercial arbitration case digest, most states apply this threshold of public policy as a fundamental principle of the procedural law or substantive law of the enforcement state. However, only on several countries apply that. It might be other states apply differently. So to support the pro-enforcement of the arbitral award and a harmonization of the enforcement of the award, is it possible for UNCITRAL to amend the model law to include the threshold of public policy, or UNCITRAL would let it be open for the states to interpret it differently? I have the honorable the speakers understand.
I think I got the gist of his question, although the connection.
Should I repeat my questions?
No, I think I had the gist. Let me see. So again, as I had answered your colleague Arvania before, whether UNCITRAL adopts something or changes its rules or amends its rules, it's a state-driven, stakeholder-driven process. So if there is an appetite to change that term, public policy, which we all know is a very charged term, then that would have to be brought to UNCITRAL, and then states and stakeholders would need to discuss it and agree on it. Now, with regards to states having adopted the model law, you can look at how they've interpreted these particular provisions, especially with regards to public policy there on the case law and UNCITRAL text database. I would also say that that there may be states who have adopted the model law, but haven't yet told us, or we're not yet aware. So again, like with the case law, if you're aware of this development, please just send UNCITRAL RCAP an email. We have a status table on the website that lists the states and jurisdictions that have adopted the model law. That's where the information in my presentation came from. And, you know, there may be states who have adopted it, but are not there. So they're actually model law states, we just don't know it. There might be states that maybe they haven't adopted the model law in full. And that's why they aren't listed there as a model law state, but it could be that they interpret the provisions that you cited in a uniform way, like the other model law jurisdictions. So I'm optimistic because many states now are familiar with how other states interpret this. And so I think it's going towards uniform interpretation. So I would leave it at that. Thank you.
Yeah, thank you very much, Sandy and Ms. Athita. The last question maybe come from Adinda Putri. Please, Adinda Putri.
Okay, thank you, Ms. Helita, Ms. Athita, and the speaker for the opportunity. Let me introduce myself. My name is Adinda Putri Denisa from the class Arbitration Law and Alternative Dispute Resolution A. I want to ask some question. In carrying out trade cooperation relation between countries that use electronic transactions, of course, there are violations of the law on electronic transactions law, violence in electronic commerce transactions, and other legal actions in cyberspace are a very worrying phenomena. Given the action of carding, hacking, cracking, phishing, booting, virus, cyberquatting, fraud, terrorism, dissemination of destructive information like how to create and use of bombs has become parts of the activities of Internet and Information and Communication Criminals Technology or ICT. Violence of law with instrument information technology is often difficult to solve because in addition to illegal acts, it was committed by subject who use sophisticated technological means and whose whereabouts were difficult to trace. The activity in question is often carried out from outside territory Indonesia, so this makes it more difficult to prove it compared to ordinary unlawful acts. And what is being questioned is how to resolve extraterritorial case like this when referring to principle of the UNCITRAL model law, whether to prioritize the use of domestic law or still revert to UNCITRAL model law. Because not all provision in domestic law include all provision contained in the UNCITRAL model law. Thank you.
Thank you. So the issues that were mentioned with regards to cybersecurity, terrorism, and all those, they actually aren't covered by UNCITRAL instruments. The UNCITRAL suite of instruments on e-commerce law, you can see, they pertain to legal provisions that would facilitate cross-border transactions involving electronic transactions or electronic transferable records. So you can look at our e-commerce instruments for more information on that. Indonesia hasn't adopted those yet. Indonesia is currently party only to the New York Convention, but with many regional trade agreements going on that actually adopt the UNCITRAL e-commerce instruments as benchmarks, including ASEAN, I think it would be an interesting project for Indonesia to look into. So there you have it. I think we can put in the chat box, maybe Tracy, we can put in the chat box the link to the UNCITRAL e-commerce instruments so you can look at those. And there are other UN bodies that would deal with the issues that you mentioned, but it's not UNCITRAL. So thank you.
Yeah, thank you, Adinda Putri and Ms. Athita. The last one, maybe, question from last month. Please, last month.
Okay, am I audible, ma'am?
Yeah,
okay.
I can hear you.
Okay, thank you for the opportunity. Maybe for my questions, my questions goes to Ms. Kim. Okay, 안녕하세요, Ms. Kim, 제 이름은 라스만 예요. 저는 바자자란 대학생입니다. 그리고 세계 월전 한국에서 공부해서 아주대 교환 학생입니다. First of all, I'm really amazed with your presentations, especially talk about the introductions and the commenting about UNCITRAL itself. I'm curious about one thing, especially related to international investment. I just want to know about how significant UNCITRAL role in terms of to maximizing the international investment for all countries, especially in the Asia Pacific, or maybe you can share from your own professional experience about what the most frequently problems that UNCITRAL face in terms of how to arbitrating or managing these issues, because we believe that all countries in the world has their own unique strategies in terms of increasing the number of parties to involving in the economic development, especially in South Korea, for example. So I just want to know about what the most frequently challenge or problem that UNCITRAL face nowadays related to international investment itself, and how significant UNCITRAL roles in terms of to help and facilitate those Asia Pacific countries in international investment. Thank you. Kamsahamnida.
Thank you, Salman. Maybe Hangyeol, Mrs. Kim can answer, and then Ms. Athita. Please, Ms. Kim.
Yeah, thank you, Lasman, for the question. Athita, could you cover the answer for Lasman's question?
Oh, yeah. So I hope he didn't answer anything in Korean that I had missed. So, but I think he basically introduced himself. So that's like based on my basic knowledge of Korean. If I miss anything, let me know, Hangyeol. So UNCITRAL works on investor-state dispute settlement, which is really a specific aspect of investment. So UNCITRAL Working Group 3 works on this, which is what Hangyeol had mentioned in her presentation. Now, you know that with investment, with any type of investment, there's the potential for a dispute, you know, like with any type of contract. So UNCITRAL's work in terms of facilitating trade and investment on this particular aspect is to ensure that there's a legally harmonized regime that would enable and facilitate trade and investment through legal predictability and certainty with regards to dispute settlement. So that's how our connection is with regards to investment. And there's also how our work facilitates commercial transactions themselves, which would lead to increased trade and investment. For example, our uniform sales law, the CISG, which was actually the theme of the first event that we did with UNPAD. With regards to investor-state disputes, UNCITRAL doesn't administer the disputes. It's not part of what we do, and we're not allowed to do that. What we do provide is the rules. So for the arbitration rules, the New York Convention and things like that, the instruments that will be used to resolve the disputes. So, yeah.
Yeah, thank you, Ms. Athita. Maybe it's the last question. And wait, the last question, I think from me for the student who wants to do the internship in UNCITRAL, please raise hand. Student, maybe you can prepare yourself to register and contact Miss Tracy. Thank you very much. And I think this is the end of the discussion session of the webinar. And before we move the next agenda, we would like to request closing remarks maybe from our speaker. We start from Ms. Athita. Please, your closing remarks.
I feel like I've talked too much already today. I would just add a simple note of thanks and gratitude to the organizers, to UNPAD, to the embassy. I know both the ambassador and Eric are really very busy. I think they're both already attending other meetings. So thank you very much for Indonesia's support for this event. We look forward to hosting the event on an annual basis going forward. So that's it for me. Thank you very much.
Thank you, Ms. Athita. And the second closing remarks from Ms. Kim. Please. Ms. Kim.
Thank you very much, UNPA, for organizing this remarkably well-organized event today. And I'm pleased that so many students and faculties are interested in our area. And we are looking forward to the continued collaboration with UNPAD and Indonesia. Thank you very much.
Thank you very much, Mrs. Kim. And the last closing remarks from Ms. Tracy Choi. Please, Ms. Tracy.
Yes, thank you so much for UNPAD for organizing today's event. It is really our pleasure to organize the inaugural Indonesian AP Day events with UNPAC. And we're excited to see that there are so many students joining our non-seminar today. So really hope that the students enjoy today's event. And thank you again to UNPAC, and we look forward to further collaboration. Thank you.
Thank you very much. And I think we have continue other collaboration after this event. And finally, we from Transnational Business Law Department, very honored about this collaboration. And maybe we can have arranged another program from academic collaboration. And hopefully our speaker can visit us in Indonesia. And for the participant, thank you for the participation. And this event could be accessed in our YouTube channel, Transnational Business Law Digest, and looking forward to welcome you again in another event. Once again, thank you very much for Ms. Athita, Ms. Kim, and Ms. Tracy Choi. Thank you for all the committee and the student and all the participants. And also thank you for our team, Pak Mursal, Labib, Nicholas, Pak Wahyu, and other lecturers that attend this webinar. Once again, thank you very much. And I give the session to the master ceremony, Habib. Thank you.
Okay, thank you. Thank you to the speakers. Thank you to the moderators. That was very, very insightful. Very, very great discussion. At this moment, I would also like to remind the participants who are still here that the attendance list can be filled via the link sent in the chat box by the committee. And lastly, before we end this all, there will also be a closing remark and a handing over of certifications as a token of our appreciation by the head of Transnational Business Law Department, Dr. Prita Amalia SHMH AIR. Dr. Prita, are you here?
Yes, thank you, Labib, for the time. And thank you. Good afternoon, everyone, and also for the speaker for today's webinar. As a closing remarks, I would like to thank you and really highly appreciation for the UNCITRAL RCAP to support Transnational Business Law Department to deliver the arbitrations and ADR, the development of arbitration and ADR.